Hours after the 7-judge bench led by the President of the Court of Appeal, Daniel Musinga, started hearing the appeal filed by the proponents of the BBI and IEBC challenging the ruling by the lower court that the BBI process was unconstitutional, the bench made its first ruling that favored the IEBC and the proponents of the BBI.
In our view, the question that remains for determination is relevance and weight, and which shall be dealt with in the judgment. Accordingly, the application to strike out parts of the affidavit is declined.
The respondents had asked the bench not to allow IEBC to table new evidence on grounds that it would be unfair to allow new evidence when the case has actually commenced.
The respondents were only supposed to respond to issues related to the production of the documents stated in our application, that is the JLAC report. Now, the Gazette notice that is sought to be introduced has nothing to do with the JLAC report.
For that reason, we will very humbly urge the Honorable Court to strike out that Gazette notice. They are trying to close the stable long after the horse has bolted.
The Wafula Chebukati-led commission challenged the judges of the lower court findings on quorum, voter registration, and verification of signatures, as well as public participation. The lower court had ruled that IEBC has no quorum with only 3 commissioners, hence cannot conduct a referendum, that they have not been conducting voter registration.
That issue is one of the grounds of appeal that we have. The issue of the mischaracterization of continuous registration of voters, and you heard Dr. Diankolu say that we talked about revision of the register.
IEBC has been operating with only 3 commissioners for the last 3 years after the resignation of 4 IEBC commissioners. The Commission's case is that, among other things, the process involved public participation, in which the BBI journey involved holding meetings in all the 47 counties. Chris Dairu, KTN News.